asking a lawyer to speak for 10 minutes is a little counterintuitive. Used to charging by the hour. This presentation could have the subtext, I suppose, as surveillance on a theme of Tom Bingham, the former law lord and great hero.
Can't hear you, sorry.
Ah.
Yeah, we've got it down.
Is that better?
Yeah.
Great. Yeah, I was reflecting on the fact that this could be the subtext. So this could be a theme on the lines of Lord Bingham, the former law lord. As I'm limited to 10 minutes, I've taken the usual step of writing everything I intend to say pretty much down. So I'm going to follow it by rote. The background to the United States undertaking mass interception of communications after 9/11 without judicial warrant has had a very interesting history of legal challenge even within the United States itself. In August 2006, a federal judge sitting in Michigan held that interceptions without any judicial warrant violated the terms of the Foreign Intelligence Surveillance Act 1978. The US government had argued that the President's action was within his lawful compass as their Commander-in-Chief. The judge, in rejecting the argument, held very eloquently that there were no, quote, hereditary kings in America. The decision was later overruled by the US Court of Appeal, and the Supreme Court declined jurisdiction to hear an appeal. A year later, President Bush announced the abandonment of the warrantless wiretapping program. Lord Bingham, sadly now dead, was concerned about the UK's complicity with the United States in the combined response of the two countries to the terrible events of 9/11. He said in his prize-winning book, which I advocate to all of you to read, The Rule of Law, published shortly before his death, the following: the advent of serious terrorist violence carried out by those willing to die in the cause of killing others tested adherence to the rule of law to the utmost. As it is their duty, that is the states, to protect their people against the consequences of such violence, and the strong temptation exists to cross the boundary which separates the lawful from the unlawful. Bingham cited in support of this position the Council of Europe in 2002. They said this: the temptation for governments and parliaments in countries suffering from terrorist action is to fight fire with fire, setting aside the legal safeguards that exist in a democratic state. Let us be clear about this, said the Council. While the state has the right to employ to the full its arsenal of legal weapons to repress and prevent terrorist activities, it may not use indiscriminate measures which only undermine the fundamental values they seek to protect. For a state to react in such a way would be to fall into the trap set by terrorism for democracy and the rule of law. Not even Lord Bingham could have known what in fact the US and UK governments had been engaging in terms of mass surveillance, probably even as he was writing his short thesis. Indeed, if it had not been for Edward Snowden, none of us may ever have known the extent and pervasiveness of the mass surveillance that has been taking place. It was very disappointing, I say disappointing here, but it was very disappointing to read last week that Lord Carlisle described Mr. Snowden and those journalists who published his disclosures as criminals, and not to grace them, he said, with the label whistleblowers. It's interesting for me as a lawyer to contemplate the term whistleblower briefly. The greatest modern triumph in English law, at least, for this often maligned individual is to be found in Sir Richard Scott's report following the misguided Matrix Churchill prosecutions, which some in this audience may remember. In that case, a Matrix Churchill employee had warned the Foreign Office that the company was supplying munitions-making equipment to Iraq. This letter, which Lord Scott described as highly significant, was kept secret from ministers and from the defendants for over 3 years. However, it played a crucial part in Michael Heseltine's decision not to sign a public interest immunity certificate for the purposes of the Matrix Churchill trial, and which led to an Official Secrets Act trial against a number of individuals being reported. With the existence of this letter, it was clear to the officials advising Heseltine that there was a whistleblower who might well go to the press alleging a cover-up. It all sounds very familiar. An internal memo from the DTI recognised the significance of the letter, and this is what the memo said. This is the advice to Mr. Heseltine, the Secretary of State at the time. The difficulty, of course, is not simply that the letter exists, but that the writer of the letter no doubt exists. And even if he has not so far been involved in the proceedings by the prosecution or the defence, he may well make the existence of his letter public. The chances of him doing so will no doubt be all the greater if he's one of those who is already redundant or will soon be made redundant next month. It is tempting to suggest that we might claim PII for the letter. What an extraordinary statement to make, bearing in mind the observations he just made earlier. But I fear that by doing so, in the face of the possibility that information in it may well appear across the front page of the tabloid press during the trial, it makes me diffident to suggesting it. It's tempting to categorise the nature of the advice given to the Minister as having reluctant integrity. I have little hesitation in concluding there would have been a serious miscarriage of justice had the writer not made the disclosure that he did. Sadly, based on the definition of a protected disclosure under the Public Interest Disclosure Act 1998, Mr. Snowden's revelations would not qualify on the face of them as they amount to an offence under the Official Secrets Act 1989, which the House of Lords held in the David Shayler case, carried with it no defence of public interest. Since Mr. Snowden's disclosures, there have been 3 developments which I consider worthy of debate. Before I paint in the detail, it's important to prepare the canvas as context. The intelligence agencies in this jurisdiction are governed by short statutes, which were extracted from the governments of the day with considerable reluctance and under the threat of challenge either before the European Court of Human Rights or had already been the subject of adverse judgments. The Security Service Act 1989 the essential ingredients of it are there. You will see, I think, 2 things of significance. First of all, that it needs to put into arrangements for securing information that it gets is obtained in the proper discharge of its statutory functions, and that it can disclose such information similarly in the discharge of its statutory functions. And those statutory functions are classically national security, economic well-being of the UK, prevention and detection of serious crime. Similar provision relates to the Act which placed MI6 and GCHQ on the statutory footing for the first time in its history. At their core, the agencies can receive and disclose intelligence in the discharge of their statutory functions, as I say, national security, etc. And this is largely a matter for them to determine. Their activities are regulated, so their actual surveillance activities are regulated by the Regulation of Investigatory Powers Act 2000, the most comprehensive piece of legislation we have in this jurisdiction, monitoring and purportedly regulating surveillance activities. But other than where their actions would amount to a criminal offence, the 2000 Act is in fact no more than a voluntary code. There is a general safeguarding for lawful conduct contained in the little-known and penultimate provision of the Act, Section 80. Many of you that have tried to digest the Regulation of Investigatory Powers Act 2000 may very well be forgiven for giving up after the first few sections. This is the penultimate section in the whole Act, and a brief review of it will reveal that it in fact requires no organisation that can carry out surveillance, even the most pervasive and intrusive surveillance, to in fact get an authorisation at all, unless it would amount to a criminal offence. And incidentally, the mass acquisition of comms data or even content data, i.e. an interception of communication, does not amount to a criminal offence if the comms provider or a person with authority for running the comms data systems gives their consent. And as we know, the comms providers, certainly in this jurisdiction, have been doing so at large. The practical effect of the legislation is that if the UK wishes to receive intelligence from a foreign power, it can do so without any authorisation being required. It can also disclose intelligence to foreign powers for all practical purposes at will. Indeed, the agencies have only ever been seriously exercised about disclosures when it comes to disclosing matters within civil proceedings, such as the Omagh bombing case, for example. In those circumstances, they have acted quickly in response to ensure that secret hearings are possible where necessary in such cases. This liberal power carries with it a real imperative that our agencies must act with acute integrity if the position is to be sustained without real public outcry. Clearly in the United States, Mr. Snowden felt less than confident that its agencies were doing so. Our Foreign Secretary's response to the revelations was to declare that if people were doing nothing wrong, then they have nothing to worry about. You may remember Steve Bell's cartoon in The Guardian, which in my opinion may become an iconic image of our age. The difficulty with Mr. Haig's position is that it is inconsistent both with domestic and European law. As to the former, constitutionally, in English law, the position is, and always has been, that unless something is prohibited by a piece of legislation or the common law, a citizen is entitled to engage in it. And as to the latter, the principle of legality is enshrined with the notion that before a state can do anything in terms of intrusive investigative techniques, a subject ought to know its scope and reach. Mr. Haig's proclamation could not have been more fundamentally flawed. The second issue are statements by the Director General of the Security Service and like-minded individuals that what Snowden has done is undermine counter-terrorist activities by the state and assist the terrorists. Mr. Parker has the advantage of all of us. He makes such public statements as he deems appropriate, having regard to the office that he holds. But if any of us seek to challenge his viewpoint, we are met by the wall of silence and government policy that is neither confirm nor deny. We as the collective public are entitled to know the basis for his assertion and the evidence to support it. If his central premise is correct, then it is impossible for him to argue that by setting out the evidence, further damage could be caused. I also come back to this, that if agencies acquire mass data, they must review mass data. Whilst doing so, they may be missing other opportunities to track down terrorists and stop atrocities. Few of us will ever forget the image of an unarmed, off-duty British soldier being hacked to death in broad daylight in the capital city, and the suggestion that those responsible may have been approached by MI5 to act as informants or were on their radar is understandably of considerable public concern. Finally, there is the revelation reported in The Guardian last week that GCHQ repeatedly warned that it feared a damaging public debate on the scale of its activities because it could lead to legal challenge against its mass surveillance programs. This included lining up, according to The Guardian report, sympathetic people to help with, quote, press handling, including, no great surprises, Lord Carlisle, who I'm somewhat relieved is not speaking here this evening, the former terrorist watchdog. More worrying is the presence of the name Sir Swinton Thomas. Probably doesn't mean much to many people in this audience, but he, for many years, was our so-called independent Interception of Communications Commissioner. As a lawyer, the personal significance of the Snowden revelations are not just the trampling of the citizens' rights in terms of the perniciousness of mass surveillance, but the complicity of governments in acting contrary to the rule of law and without transparency or accountability. We ask often, sometimes rhetorically, who guards the guardians? In the context of terrorism and the rule of law, Lord Bingham gave the last word to Christopher Dawson, who in 1943, when Britain and the United States were pitted against the great evil of Nazism. As soon as men decide that all means are permitted to fight an evil, then their good becomes indistinguishable from the evil that they set out to destroy.